Perfect. Okay. Hello, I'm Laura Shaughnessy, and I serve as chairperson for the Professional Counseling Advisory Committee of the Kansas Behavioral Sciences and Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic medium. Leslie Suister. Regulatory Board.
Here.
Thank you. And we know Kenneth Huey said he would not be here. Bob
Oh, I'm
Kircher.
here.
Oh, Ken is here. Hi, Ken.
Sorry, Kenton. I missed.
Oh, got it. Okay, so Kenton is not here. So Kenneth Huey, can you say present again?
Can we have people mute? There's background noise. I can't understand you. Sorry.
So can everybody please mute unless you're saying present?
So can it have people mute again?
Yeah, and if you have the YouTube stream on the background, go ahead and mute that. It's going to be on a delay, so it's going to echo everything that we're saying right now. So it's okay to watch that stream, but go ahead and mute that if you have it on in the background for volume.
There we go. It's quiet now.
Thank
Okay, let's
you.
start the roll call again. So Leslie Suister,
Here.
Kenneth Huey,
Here.
Bob Kircher,
Here.
there you go. Kenton Olaf. Is he here? No, he's not here. Gary Price.
Here.
Elaine Tetchick.
Here.
Andrew Secor. So he is not here. I note the following staff members are also present. David Fye,
Here.
Leslie Allen,
Here.
Ashley Van Buskirk.
Here.
And Jan Arndt.
Here.
Great, thank you. Next, David Fye will read a message concerning this meeting being held remotely.
This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the advisory committee to provide public comment or answer questions from individuals. There will be no public comment at the meeting today to ensure adequate time for the items currently on the advisory committee's agenda. Because we're conducting the public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Because the emergency declaration that was issued for the COVID-19 pandemic has been extended to May 28th, 2021, the meeting is being conducted remotely to comply with health and safety concerns, as the board's conference room cannot accommodate social distancing for everyone in attendance. However, access to the meeting is being conducted by a medium of interactive communication that allows members of the public without cost to attend the meeting through the use of a conference call and on the board's YouTube channel. While the meeting is being conducted remotely, the requirements of the KOMA are not suspended. As such, we will be conducting the meeting pursuant to KOMA and KAR 16-20-1 concerning compliance with the KOMA during an existing emergency disaster declaration. On April 20th, 2021, we sent notice of the advisory committee meeting to all individuals who requested notice of the advisory committee meeting. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting materials were posted to the board's website on the day of the meeting. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240. Each member of the advisory committee staff or presenter shall state the person's name and title each time the person speaks or votes. Each participant to the meeting shall ensure microphones, phones, and other electronic devices are on mute when the participant is not speaking. Each motion shall be clearly stated before the advisory committee votes, and each advisory committee member will vote when their name is called. The chairperson will announce the result of the final vote. The advisory committee lacks authority to delegate a member of the committee or staff to sign any binding document on behalf of the board. Thus, no such statement or motion will be made. A recording of the meeting will be posted to the board's website. The advisory committee has the following items listed on its agenda: call to order and roll call, opening remarks, agenda approval, review and approval of minutes from the meeting on February 1st, 2021, executive director's report, old business, new business, and adjournment. The advisory committee's agenda does not include an executive session. If the advisory committee elects to go into an executive session, the advisory committee will follow this process. First, the advisory committee must be in an open session before going to an executive session. Then an advisory committee member must make a motion to recess for an executive session that is seconded by another advisory committee member. Each advisory committee member will then vote. A majority of the advisory committee must vote in favor of the motion to exercise the executive session. The chair will announce the result of the vote. The motion must contain a statement of justification for closure and is subject to be discussed pursuant to KSA 75-4319B, and the time and place the open meeting will resume. If a motion for executive session passes, the conference call will be placed on hold. Attendees may stay on the call or return to the conference call number at the expiration of the executive session to attend the remainder of the meeting. The public will be excluded from the executive session portion of the meeting, as the executive session will be conducted by electronic means that is not available to the public. When the board members return to the conference call, the open meeting will resume through the conference call. The complete motion for an executive session will be recorded in the minutes.
Okay, the meeting is now called to order and the advisory committee will begin its discussion of the first item on the agenda. So good morning, everyone. We need the agenda approval from the last meeting. So I need a motion to approve the minutes, and does anybody have any question?
I motion that we approve the minutes from the last meeting. This is
February
Robert Butcher.
Okay, I need a second.
I'll second. Leslie C. Wester.
Thank you. All in favor, say aye.
Aye.
Aye, aye. Any opposed? Okay, so the minutes from the previous meeting, February 1st, 2021 have been approved. Do I need to get an agenda approval as well for today's meeting?
That just gives you the opportunity. If you wanted to make any further adjustments, you could do that, but you don't need to take a vote on approving the agenda. So.
Okay, does anybody have anything they need to add to the agenda today? Okay, I'll proceed. So at first we have the executive director's report. So Dave, do you want to take it from there?
Sure. I just want to update the advisory committee on a few different items. First, the last time you met, there was a state of emergency for the pandemic that the governor had declared. This originally started back in 2020, and there was a series of disasters that were declared by the governor. At first, it was governor's action, and then it became sort of a joint action between the governor and the legislature. At the time that you met back in February, the most recent version was going to be ending on March 31st. And there were a series of executive orders that the governor had issued along with the states of emergency. One that affected our agency was to not expire professional licenses under certain regulatory boards until the end of the pandemic or until the date that current emergency was going to end, which would have been March 31st. So about 10 days or a week before that March 31st end date, we sent a message to licensees whose license had expired during the pandemic that had not renewed, letting them know about the upcoming deadline and asking them to take actions so there wouldn't be any issue with their license. And then just a few days before that date, another state of emergency was issued, but there wasn't an executive order until April 1st. And on April 1st, the governor did issue another executive order to continue the stay on expiring professional licenses until May 28th, 2021, or until the disaster is declared ended. And so that is currently the date that we have posted on the BSRB website to licensees to let them know that is the date that the licenses will essentially be expired. But the stay was put in place until May 28th or until the disaster is declared over. Since that time, there's been another couple of actions with executive orders. The governor did issue another executive order, I think just last week, that provided a little bit more flexibility to agencies that they could go ahead and look to take action prior to that May 28th date, or could give agencies the flexibility to go ahead and not expire licenses. So that is something that the board will be taking into consideration and talking about at the upcoming full board meeting on May 10th. But I want to make you aware of that. In terms of other legislative updates, so before the legislature went on their break, prior to coming back for this veto session, omnibus session, the legislature did pass a budget bill. The budget bill did have about 19 vetoes, but the governor did sign it. None of the vetoes affected the BSRB's budget. So the budget for the next 2 years has been approved in version by the legislature and the governor. So that is taken care of. The bill that the BSRB had requested, that had been going through the committee process and had included a number of statutory changes for licensees. On the House side, that was House Bill 2208. On the Senate side, that was Senate Bill 238. As the bills both moved through the different committee process and the chambers, they did go ahead and pass with a number of amendments. A number of bills were added into the contents the BSRB had requested in the initial bill form. So there were some modifications and some adjustments. 238 has become a different subject bill, so you don't need to worry about 238 anymore. But House Bill 2208, that is really the bill that has the statutory changes for the BSRB. And that did pass both the House and the Senate. It went to conference committee because the versions that passed were in a different form. And in the conference committee, the legislature made some further changes, sent it back to each chamber to vote on the combined conference committee, and that bill did pass. It went to the governor for action, and the governor did just sign that. The effective date for the bill originally was going to be upon publication in the statute book. In the conference committee, the House and Senate members who were on the conference committee did make an adjustment. As I mentioned, several other bills were added into the contents of the original BSRB bill. So now it has about 5 or 6 different bills into that combined bundle. The effective date was changed in the conference committee from upon publication in the statute book to upon publication in the Kansas Register. And I'm not as familiar with effective dates in the Kansas Register as the statute book. The statute book comes out usually sometime at the beginning of July. The Register is a weekly publication by the Secretary of State's office, but it doesn't always include the most recent information. So I have been talking to the Secretary of State's office. That has not been published yet. They believe the BSRB contents might be published at one of the upcoming publications. The next one, I think, is going to be on May 6th. So we'll be watching for that. But in the meanwhile, we're working on a number of different questions for the board to take a look at. There are going to be some possible regulatory changes that will need to go hand in hand with these statutory changes. There may need to be some clarification from the board in terms of how to treat some of the things that are in place under the existing set of rules when the rules change for certain licensees or those attempting licensure. So we're putting together a list of these items for the board to consider. But the good news is the BSRB bill has passed. We're just working on the logistics for the implementation. And then another bill I just want to put on your radar. There was a bill earlier this session. The BSRB did speak about it. It was House Bill 2066, and it was a bill that concerned regulatory changes for lots of different agencies, but specifically was directed towards shortening the time for processing and making some changes to applications for military members and military spouses, as well as individuals who were seeking to establish residency in Kansas, and then it had a clause in there about individuals who had already established residency. But some of those provisions we're still working through. As I mentioned, it affects a lot of different agencies. So I was part of a meeting with some other small agencies last week, looking at how we're going to be able to track some of the information with that bill, and then working through the logistics to process things for that new bill that's going to change some of the timeframes and some of the way that we process those military applications and military spouse applications. So aside from that, just here at the office, we are working on continuing to improve the processing time for our applications, working on customer service items. Just a few weeks ago, we were able to get Jabber technology for staff members. I think I had mentioned Jabber maybe to you before. Jabber is a way that we can make phone calls for using our computers. So we still have a number of staff members working from home. Department Administration and Department of Emergency Management have said we're not able to bring back staff full-time across the board yet, but they expect to give us some announcement on changing processes in the next few weeks. But in the meanwhile, we're trying to be as trying to take care of things as best we can while we have staff members working at home, so that Jabber technology has been helpful to allow more conversations back and forth. So just wanted to update you on a few things in terms of the agency and the legislative items, and also here working in the office, but I'd be happy to speak to anything else or answer any questions you might have.
I have one question and a comment. David, the House bill the governor signed, did you say that was 2228?
That is 2208.
Oh, wait, sorry. Okay, thank you.
Yeah, and that bill has a number of different bills in it. So if you're looking through it, you may just need to look at certain portions of the bill that reflect the BSRB.
Okay, my other is a comment related to the exigency with the COVID. I was one of the ones whose license had expired, and I renewed my license, but in the comments or in the notes, it said that my next date of expiration would be 2 years from the original date of expiration. So mine was January 31st of 2021. But it also said that CEUs could not be counted that were taken between January 31 and the current renewal period, which was, let's just say, March 15th. Now, I presume that's going to be April 30th. So theoretically, if we extend this out, you know, and let's just say that, you know, the restrictions continued for a 2-year period, there would not ever be a time period in there where you could take CEUs to count towards the next renewal. That just seems to me logically inconsistent.
Well, so I think, you know, the way that it works is when you come up for licensure renewal, and Leslie might be able to add a little bit more on this too. When you come up for the renewal process, you're saying that you've met all the qualifications needed to do the renewal process, and part of that is affirming that you have all of the continuing education hours. So they look at what you have at that time that you renew, and then you're able to accrue hours for the next time period after that until the next expiration date. And so if people renewed when they were originally up for renewal, then it would be just like it normally was. But I think that's kind of how it's been executed, right?
Right. If they waited to renew because they needed CEUs, then they couldn't use the CEUs for this renewal that they extended for the next renewal cycle.
But you could use CEUs between your last expiration date and your current time of renewal.
If you renewed on time, it would be just like normal.
Right. But
right.
I didn't renew on time because I didn't realize until I got the postcard from the board saying it was going to expire by March 31.
Okay. Right. So now I've confused myself. Repeat the question.
Okay. So I renewed, let's just say close to March 15th.
Right.
Whereas my expiration date was January 31st.
Right.
I only used CEUs. I didn't need anything from January 31st to March. But so it says then my next renewal date is from my original renewal date, which would be January 31st, 2023.
Right.
But no CEUs can count until those taken after March 15th of January 21. So I have 3 months less to get CEUs.
Right. And I mean, technically, if you didn't need to use them for the renewal through the 31st and you were audited, then it wouldn't matter because you had the amount you needed for your renewal. But if someone is not renewing, because everyone was given the extension so that because of the continuing education requirement. So if people aren't renewing, then they have to use, and they need the CEUs that they've been accruing. They can't use them again on the next renewal. So I guess we never really talked about if someone renews late that didn't need the CEUs.
Yeah, I'm not really. No, I understand CEUs could not be doubly counted. I understand that. Yeah. Well, I just thought I would bring it up because logically, I mean, the pandemic could be carried out for 2 years. If that happened, then there would never be a time period where you could get CEUs.
Well, I think I see what you're talking about. But it really, even if the pandemic were to be extended past that May 28th date, it really just looks at when you renewed. If you wait longer to renew, you are shortening the time period where you can accrue those hours. But if you go ahead and renew, like you did in March, then that's where the time starts until the next expiration date. So if they were to continue past the May 28th date, now they have said in this most recent executive order that it's making it more flexible. And so it's not an automatic extension on this provision in terms of the licenses. So that is a change. But I think I see what you're saying. We've had some discussions about this. We want to make sure that people, we could easily track when people receive their CEs in regards to which time period one versus the other. And we thought this would be sort of the cleanest way to do it, so that you could see you accrued all the hours and then you renewed. And then for that next renewed period, you could kind of see from that renewal date until the next expiration, what hours you accrued during that time period. So.
Okay, thank you.
Any other questions for David? So David, I'd like to thank you for the hard work that you've done regarding the House bill, advocating for changes and being involved, and also for keeping us updated. You do a great job of keeping us updated on what's going on, and it's very helpful. So thank you.
You're welcome. Thank you.
On behalf of the committee. Okay, so we'll move on, and thank you for that report. Let's talk about old business. The old business item that I have is planning any important work for the year. And if you look down at new business, some of it's there. Some of those things are already coming up and being worked on. But I wanted to ask first, are there any things that, any of you feel are a strong priority for us to tackle this year? Anybody have any ideas? Seems to me like the work is naturally coming up. The items that we are talking about in new business are things that have evolved. And so we certainly have enough to do. But if anybody has any old business or any, ideas for other things we need to do, it's very important for us to get started on them. Okay. That being said, I guess we can go to new business. So the first thing on our agenda in new business is the proposed multi-state compact. The MBCC is proposing that states become a part of this compact. Has anybody been on the website to read about it? The language on the MBCC website is pretty general, but has anyone been on there to look? And does anybody have any questions about the compact?
Well, and Laura, I might say just a comment. This past few months, the board has had some discussions about one proposed compact for another of the professions, the SIPAC compact for licensed psychology, and that compact really focused on telehealth, and that made it a little bit of an interesting one to look at, because some of the other compacts in the past for other professions have really dealt looking at general practice between states. So the SIPAC compact was one that has been, at least on paper, being considered for a few years now, and just recently had enough members to actually start to look at what does it mean to be put in practice. This compact that was proposed by MBCC is a little bit different in that it is very, very new. This is not something that has been passed by a number of states. It is something that has been proposed. The document that you received in your email, it's been posted to the board's website, is sort of some model language that MBCC has proposed, about 26 pages. I did ask Jan, attorney for the board from the Attorney General's office, to go ahead and review that language for the compact. And I thought it might be helpful for her to kind of provide a little bit of information for the advisory committee as well. But I just kind of wanted to, and then I think there's one other document you received, which was just sort of a, I think 2 or 3 page comment from MBCC regarding, their thoughts on a compact for professional counseling. But I just wanted to frame that for the advisory committee as you're getting into your discussion, because this is a compact that is very, very early on in the process. It's not something that is at this meeting being brought to the advisory committee or the board by different advocates. It's just something that, as we've tried to look at what's going on at the national level, what are the conversations that are taking place, there have been some discussions about potential compacts. And so when I received this language just, I think about 2 weeks ago, I wanted to make sure to get it out to you so you could have a chance to know that this is something that is being proposed. It's out there. You can take a look at it. For this thing to be adopted, it would be similar to how SIPAC was, and that a number of states will have to pass it. So it would need to eventually be put in the form of legislation that the legislature would be considering if it was brought forward in that fashion. But, like I said, I just wanted to get this language out in front of you so you could start to have the conversation, look at this, and then be aware of what MBCC is saying about their thoughts on compacts.
Jan, have you had a chance to look through the proposal?
Yeah, I've gone through it, and it's different than the psychology, the SIPAC is. It's not the same. This is more in line with the compacts that other agencies have. Basically, one of the big differences is that instead of the licensees applying with the association, they are applying to what's referred to as the home state, which is their residential state. And it does allow the home state to charge the applicable fees. So that's one big difference, is that the state gets to look and determine who is qualified to be in the compact. They can, but it also doesn't prohibit anyone from getting what they refer to as a single state license. So they could get have Kansas as their home state and be under the compact, but yet they could go to another state and still get a single state if it wasn't a part of the compact or something like that. So I'm trying to think, I don't know if you have read over and have any questions that maybe you want to address first, rather than just trying to go through this kind of bit by bit. Is there any preference that you would have?
I don't have a preference. I think it's important to understand the larger tenets of it, because I know there are going to be so many details that'll be worked out over time. But in general.
Yeah, and the other thing is too, is they have like a data bank. You have the National Practitioners Data Bank, which you're subject to, which goes into there for everyone. But also it looks like this association will also have their own data system that are for all the licensees who have a compact license. So that way it's like another layer, I guess, in how people could check to make sure that someone who has a license is still valid. Mm-hmm. So basically, I guess the way it would work would be that if someone resides in Kansas, they would make their application then through BSRB to be a compact member. Then BSRB would get to look to make sure that they meet the qualifications under the compact and under Kansas law. And if so, then they would give them the compact license. And under this, it gives them the ability to practice in one other compact state. They couldn't necessarily practice, say if there were 13 states, they have to pick the state that they want, other state that they would want to practice in. If they decide to move their residence, then what they have to do is to put in an application with and it's a compact state. Then they put in an application to have that state be their home state. Once the new state would approve it and become the home state, then BSRB would then convert their compact license in Kansas to a single state license, so they could continue under that to practice in Kansas. If they want to keep that as a single state, then they of course would have to apply with Kansas each year. But it also allows them to practice like telehealth. So that's like why they can, if you're in Kansas, but you want to practice in Missouri, you can do that like through the telehealth there. And section 3, which is on starts at the bottom of page 4, it lists the requirements that they have to get the license, which are pretty common, I think. I don't think it's really any too different than what we already have for professional license, professional counselors, which is a 60 semester hour, 90 quarter hours of either a master's degree or a graduate degree. And then it has about all the topics there. And they're very similar to what you have: professional counseling, ethical practice, social culture diversity, human growth and development, career development, counseling and helping relationships, group counseling, group work, diagnosis and treatment, assessment and testing, research and program evaluations. They have a kind of a catch-all, which is other areas as determined by the commission. I don't know how you know what those are. Typically, they do have what they call rule and regulation power, which makes everything enforceable. It doesn't say if they're going to do that in rules and regulations, which it probably should be to be enforceable. So that probably needs to be tweaked a bit to say that determined by the commission in a rule. Then what, if you're going to join it, you do have to have a means for investigation, but you already have that. The board has established the investigative committee. When they get complaints, that they look in to see what people have, to see if the licensee has violated any statute or regulation. And if so, they give notice to the licensee. They gather more information. Once you have all the information, then it's taken to the investigative committee for a decision. So you've got that in place already, but that is one of the things that you do have to have. The other thing that you don't have right now is that it requires a criminal history information. And it says that it has to be by the Federal Bureau of Investigation, not the KBI, when you typically ask for them to submit a KBI background check. So you do have the statutory authority to do the FBI one. I believe they got that in 2016 or something. But there's an approval process you have to go through. And I don't know, Leslie, I think you have completed the approval process. Have you not, Leslie? It's just not been implemented and training and all that.
Yeah, we haven't done the training or anything.
Yeah, it's not easy. And then there's also the people who are going to use and get the information have to be fingerprinted and pass a background check. And then you have to train it. You have to be trained on how to use it and how to dispose of it. Like, you cannot, probably they would not authorize you to get that FBI criminal background check to send it like to board members electronically because it's probably, that would be something to check out anyway, because you may not have the software to encrypt it and so forth to make it safe. But it's very limited on who can get it and who can, and what you can do with it, and then how you have to dispose with it. They also will do, come in and verify that you're doing it correctly. If you're not doing it correctly, then they can take remedial actions to take away the authority to give you the background from the FBI. One of the things that they do say is you can charge a fee for granting. If you look at CM on page 6, that you can grant a fee for granting the privilege. That's, to me, is not real clear. Other places it'll say all applicable fees, like you have an application fee that they have to pay when they file the application. And then if you grant it, then you don't give the license till they actually pay the license fee. The way that says it for granting the privilege to practice, it sounds like a license fee. So there may not be an application fee. So that language, which should probably also be tweaked to say all applicable fees like it does in other areas, so you can get an application fee and the license fee. Otherwise, you may find yourself, as more people move away from getting a license through the original initial license or through reciprocity, as they stop using those procedures and move into the compact, you could be losing money because you're not getting all the fees that you would under those other ways that people have to be licensed. One of the things is that they can't get the license if they have a license in another state that is encumbered. They have to wait. They have to get everything in compliance to get that back, and then 2 years have to go by that they have a valid license without any encumbrances. So that once they have the privilege to practice, like I said, they can go to another state and practice there. And there is an expiration date. They have to renew it just like you do your other licenses, and they have to comply with the home state in what they have to do. So if your home state requires 20 hours of continuing education, then they have to do that, and then again pay the fees. So that's not really anything too new, but if you do deny it, or if you have to take action against some place, then you do have to notify them to their data bank. Then the data bank notifies all the other compact states that they are no longer eligible to do that if you are the home state. Only the home state can take away the authority to practice under the compact. Now, what they refer to as a remote state, that's like another state that's a part of the compact where they practice. If they do something in that remote state, they have the authority to take away the licensee's ability to practice in that particular state. And then they send that information on to the home state investigates, and home state can then take away the compact privilege if they want to. But it's kind of a balancing act between the two states. There is the authority in here for a home state and a remote state to work together to do investigations to make sure that you get all the information that you need. It's kind of kind of mutual benefit for all the states to work together to make sure that licensees are competent and ethical. Let's see, kind of covered moving to another state and paying fees. It's pretty much isn't any, if they want to take investigation to take any kind of adverse action, it's not really too different than what you have now. Under section 8 on middle of page 10, kind of goes through that says that they can take adverse action under the existing due process laws for that particular state. In Kansas, we call that the Kansas Administrative Procedure Act. That's our due process law for licensees. And it's pretty much the same thing, the same kind of deal that what you've already got under CAPA. And that is you can issue subpoenas and investigation, take testimony, produce evidence. And then they have the right to go to district court to enforce it if they need to. And then it says the issuing authority has to pay any witness fees, travel expenses, mileage, and other fees in the state in which the witnesses or evidence are located. So that's going to be a little bit different. So that would be, say, if a remote state is taking action and they need witnesses or evidence here, then BSRB may have to end up paying for those expenses. So, because BSRB may have those expenses, but then it says the issuing authority, which I assume would be the remote state because they're wanting to make it, could be required to reimburse them. And it's the same thing, then vice versa. If BSRB was taking the action, but you need the help of a remote state, then you would have to reimburse that remote state or pay those expenses. So because they're practicing in other states, you may have a few more expenses than you would expect. I think we kind of covered a little bit of this stuff. And again, joint investigations they can do. The one thing is if you do take adverse action on a compact license, you are required to include a statement in that order that the person's privilege to practice is deactivated in all member states. So if you're the home state, you're taking away the compact privileges, you have to include that statement that you're going to take it away in all of the states so that all the states are aware of that, as well as the licensee, that they're done with the compact. And then again, that goes into the data system. Basically, this establishes to handle the compact. What they're doing is that there's going to be a commission formed, and it will be each compact that joins will be able to appoint one member. It can be the licensed professional counselor, a public member, or an administrator such as David could be the member. And they would be the ones who participate in the meetings, vote on rules and the regulations, that type of thing. So that is your representation in this. And it's just one person, one vote for each member in the compact. They can remove the member, but that'll be through rules and regulations. I assume that probably the rules and regulations are going to be published on their website, and a copy would be given to all the members so that they are aware of that, and you can get those on your website as well, because you'll want to make sure that everyone has access to them, because it's not going to be like a statute book or something, or a regulation where they can go like to any library and get a copy of them, or just get on the Kansas websites for those. So I hope we need to make sure then that all the rules and regulations that the compact does have applicable are on your websites. The thing that is a little bit different is because they do have like a rule and regulation authority. The way they pass those is a little bit different. It is, kind of jumped ahead a little bit. That's described beginning on page 19. And they will become binding here in Kansas for a rule and regulation. It's so many days after they get published for a permanent one. So that's a little bit different here. It becomes binding whenever that order says that it's going to be binding. So you may, get a few days notice. You may get a few months notice. It's a little different. It's also a little different. They do give out notice to people who want notice of it, and so that they can listen to the meeting on it and look at it. However, though, to have a hearing on it, as like under ours, you have to have a hearing within 60 days of when you publish it on the Kansas Register that you're going to start that you may pass, put it that way, pass the regulation. Here, I mean, you're required to have that hearing on it, even if no one requests a hearing. Here it's a little bit different. In order to have a hearing, there have to be at least 25 people who request it, or either a state or federal agency have to request it, or an association having at least 25 members have to request it, because that is new. To request a hearing requires people to ask for it. So the one thing that is here is that it does allow them to require the member states to pay a fee. It doesn't state what the fee is. Apparently it's an annual fee that's determined on a year-to-year basis, depending upon what their costs are. So, it's very possible, let's say if they have a lot of litigation or startup expenses, whatever, it's possible that your fees could be higher, 1 year from the other to the next. There's no maximum amount on it by this compact. So that could bounce around for year to year. That may make budgeting a little bit more difficult for David, but that's a possibility because there's no history on this to kind of know how they go about doing those fees. They do hold meetings, and the meetings are open to the public. They do have some ways to close the open meetings. It's very similar to what we have under the Kansas open meeting laws, but yet it's also, but it's of course more broader. Basically to discuss employment, or if a member state has not in compliance with the compact, if there's any threatened litigation, negotiations, or contracts for the purchase, lease, or sale of goods, services, or real estate, accusing someone of a crime, discussing trade secrets, just personal information, if there's going to be discussion about that, or disclosure of investigative records can be closed. And then if there's any matters that are exempted by a state law for a member state or under federal government, then they will also close it for those reasons. So if they do decide to close it, it's just a little bit different, is their council has to certify that the meeting is closed and why it's being closed, and that it was a legally sound reason to close it. And they do have, will keep minutes of their meetings. They do have immunity so that if members, your person that you send there, if there's a lawsuit and there's a law, all of that, it's very much like the Kansas Tort Claim Act, which is that if you're operating within your scope under the compact, then they will give you, there's immunity in that, so that you don't have anything personal. They will also defend you. That's going to be a little bit different. Here in Kansas, it's the Attorney General's office that would defend you if you're operating within your scope. But this says that if you're under the compact, it's going to be the commission that defends that. I'm not sure how they do that, if they would contract for someone, or, if they would use an AG in that state, because it's multiple states. They do have a thing in here, though, that if there's going to be lawsuits against the commission, then it's supposed to be brought in the state where the commission is located at. So that's the main thing, is that you have to be operating, though, within within your scope under the compact to get that immunity. So, and it also, what is requiring in that data system is that any applicant, so it's not just taking away its license or restricting a license, it also includes the denial of applications. That's kind of it in a nutshell. The rest might kind of bog you down. So I don't know if you have any questions about that or not.
Any questions for Jan?
I have a couple of questions, Jan.
Mhm.
Did they use any kind of a model like architecture or legal in setting this up?
I'm not sure how it went about getting it set up. I would assume that probably there might be some model acts out there they follow, because that's why I'm saying I have seen something. There's 3 other boards that have compacts, and this is very similar to the way those compacts are. So I would assume that there's they either may have used those kind of as a template, or there's a model act out there, something like that. But I would think that their legal counsel, I don't know, I would assume that they have some kind of legal counsel who would look it over then to make sure that everything appears okay by them. Of course, it's written to protect the commission, not the member state so much. So does that help or not?
Well, I just wonder, because there are, other professions that do have transferability.
Mm-hmm.
So I think there are many advantages to having that. I don't know quite why they would limit it just to one other state. I would think if, like, someone licensed in Kansas might want to practice in Missouri or Colorado or Oklahoma. I'm a little puzzled by that.
Well, there's 3 boards who have these compacts. One is the nursing board, emergency medical services. And then the Kansas Board of Healing Arts has one. Of course, they have one, they're kind of like BSRB where it's one board, but several professions. And they have one for physicians. And I think one is on the way through this legislative session for therapists. Is it? Can't remember now if it's occupational therapist, physical therapist. I think physical therapists are going to have one.
That sounds right.
And so the reason when those were going through the legislature to get them passed was like for EMS, where if they had patients where they had to transfer them across state lines, then they would have to find EMS people who were licensed in both states. And so that by doing this, then that way they could transfer patients back and forth across state lines under the compact. And like for nurses and doctors, it was very beneficial for those who worked on around the borders of Kansas, say like in Kansas City. So that way you could work in Kansas City and Missouri, or Kansas, Kansas and Nebraska, Kansas and Oklahoma. So that's typically where, that was the big sell. And the other selling point was as they hoped to get more medical care out to the rural areas where there was a shortage of professionals. Now, I don't know if that's come to fruition or not. You can give someone a license, but you can't tell them where to practice. I mean, that's always been one of the things that's going to bring more practitioners to a certain area. And people don't understand that when you give them a license, they're free to practice anywhere within your jurisdiction. So that's usually the big push, is to try and bring more practitioners into Kansas, and hopefully that they'll cover more of the rural areas. EMS and Healing Arts were the first ones to get their compacts. They've had them the longest. Nursing Board, I think theirs just became effective in 2019, I think, maybe 2020, somewhere in there. They had about a year. The compact was passed and it was effective, and it passed, but it didn't become effective until like the next fiscal year. And so they had a little bit over a year then to gear up for the compact. And so that way they were able to get their computer systems, applications, all of that all set by asking for a delayed effect of a little over a year till the next fiscal year. One of the things they found in the nursing board was usually in May, then as the students were graduating, they usually had a big influx of applications. But that particular year, it was not as big. And the reason was what people were telling them was the new graduates were waiting till July 1 when the compact became effective because they wanted to go under the compact. And so I think that's probably another advantage is going to be for probably younger folks who maybe don't know for sure exactly where they're going to land. They could anticipate their future, starting in one state, but then later moving to another state. For practitioners who've been in one state for 30, 40 years, this may not be something that they're interested in, but again, if they're on a border state, they may be interested in. So you could see some changes in how your licensees are becoming licensed. And as David could kind of tell you on the bills that are going through, this is what the legislature is interested in, is getting more people licensed and being able to practice in Kansas to help the residents of Kansas out. So I think, these may be more a wave of the future than we're ready for, but I think it's something that's going to happen.
Yeah, and I think, sorry.
This is Lane. So is this optional right now?
It's just.
Right now, it's just under consideration. For this to become law, they have to take it to the legislature, and the legislature basically takes this and then puts it into a statute so that becomes law. And that would be one thing that would be provisions. Some would be to sort of add, like what we did with that SIPAC, would be to add provisions in here that it's a part of your Professional Counselor Licensure Act, that you can charge all the applicable fees and amend your fee statute and stuff. So it's too late this year to get it into law. So if they were going to introduce it, it would be next legislative session, which would begin in January 2022. So this is the way it should happen, is that they come to the board ahead of time to give you time to look it over and maybe ask for some tweaks. Other agencies have found, Nursing Board was working with the association on making the tweaks. Before they got it, they were almost over the finish line when the legislature came, and without any notice to the board, they put it in a statute, and it didn't get the tweaks they wanted. So they're having to work with that. But so, if you want something changed in this compact, now is the time to discuss that and work with the association to see if you can do that. Because even though it's among many states, sometimes there is some wiggle room where certain things can be amended. And, one would be to, make sure you're getting all of your fees, your application fees and your license fees, that type of thing.
Well, and I just want to add something to that too. So this compact is very, very early on in the process. So, and I believe the threshold to officially make it a multi-state compact is when 10 states pass it. And I don't believe, I don't think any states have actually moved it to the point to where they would consider it in the form of legislation. So I don't think any state has passed it. But like I said, this is very, very early on in the process. But once states do start passing it, from what I have heard is, the model language would need to be uniform between states. And then there's some flexibility between the rules that the commission puts in place to administer the compact, or the rules and regulations on the state level and how to handle the provisions of the compact. But right now, the actual model language for the compact hasn't been passed by any states. And so it's just proposed, it's being viewed right now. And then that's what you're looking at right now. In terms of the movement for compacts, I just wanted to comment one thing, just because I've been hearing different things from different people in terms of why there's a movement right now for the compacts. And I think Jan is right. Right now there's part of the issue is that the pandemic has compacts on people's minds. I think there's also the interest in terms of portability. People want to go between different states and they don't want to live in one state their entire professional career. But I also think that there is another corner of this, which deals with the military and the military spouses, and that they know that those military service members will be moving from different states as they're stationed different places over the course of their career, and they want to make it easier for individuals to practice if they are under a profession. And so that military angle is something that is in the conversation too, as a reason why the compacts are a hot topic.
You're muted.
Thank you.
Any other questions for Jan or comments?
So when the board puts this on the agenda, probably any professional counselors probably need to, attend the meeting, listen in and see what the discussions and concerns are, because now's the time to be heard before it goes to the legislature in a statute, so that if anyone has any ideas on it, the board's aware of that. Because once it's in a statute, the only way to change it or to get out of it is to go back to the legislature and ask for the changes, or to repeal that statute. And that's how you get out. That's the only way to get out of the compact.
I have a question. Would it be appropriate to invite someone from the MBCC who is working on this to talk to our committee so that they can answer questions directly and frame them for us?
No, there's nothing wrong with that. And that's actually the way to do it, because as board members, you're not advocates for this association, so you can't speak on their behalf. So if they want to advocate it or answer questions, then they should come and speak before the board.
The committee or the board? Our committee or the board?
Well, either one. If the committee would like to talk to them, that's, ask. You're holding your meetings, remotely, so it shouldn't be any big problem, you know, hopefully if the time and dates all works for them, to get them to come and talk to the committee and then again to the full board.
Okay, so committee members, how do you feel about that? Is that something you'd like to do, is attend a meeting with some of the MBCC folks so we could ask questions and gain some clarity? Is anybody interested in doing that?
So are there two different efforts going on right now for either reciprocity or for the compact?
Well, it won't change the reciprocity statute, so that will be there. It's just giving them another option that they can use reciprocity or they can use the compact. You know, reciprocity is that, you know, they're licensed now in one state, but they want to come into Kansas and are using their licensure in that other state to get a Kansas license. This is a little bit different where they're already in Kansas because Kansas is going to be their home state, and they're applying for a compact license so that they can practice again in another state without moving or without getting a license in that other state. So it's similar to reciprocity, but there's a little bit of distinctions.
Bob, is your question pointing toward the idea that people might use compact instead of reciprocity?
No, I was following along nationally for a while, and then I hadn't been paying attention to it. It seemed like there was two different angles that were going on. One was maybe a national reciprocity of some sort, and a compact, and a couple of different organizations were proposing two different things for counseling. I was just wondering if this was the kind of has won out, or where this was at this point.
This is the only compact that I'm aware of. Have you heard it for professional counselors or anyone I know of? Only one I know of that's been given to the board. There may be some others out there, and it's kind of like reciprocity in that if you get licensed in one state, then you have the ability to go to one of the other states that's in the compact. So it's kind of dual, whereas a reciprocity, you're just going to get a Kansas license. You've been licensed somewhere else and you're going to come to Kansas and get licensed under the reciprocity statute. But unless you keep both licenses active, you're only going to be able to practice in the one that's active.
Well, and I've been trying to attend some of the national meetings to kind of hear some of the conversations. And I think there were some other concepts that were being discussed. This is the only one where I've really seen official language, so I want to provide that to you. But I'll go back and see if there's anything else formalized in terms of other options. This is the only one that I think I've received some actual tangible language, so I wanted to provide that to you. But I'll go back and I'll look to see if there's something else too.
Because we had talked about that at some point in time a year or so ago, about these kind of, it was kind of dueling approaches. And so this has become more vetted at this point, it looks like.
You know, it's been a while, but I think, I want to say maybe even years ago, that there's been proposals from like for psychologists from the National Professional Association and from the Professional Counselors Association, but they weren't like this where it was really put into a form where you would copy and paste it into a statute. It was more of an outline, like, we're thinking about doing this. How does this look to you? Would you be interested in doing it? So you didn't know any of the details. We've gotten those in the past years by, and because there was no details, the board, I don't think, really put it up for much discussion. And then it was also before compacts were really taking a stride across the country. Now, like I said, there's other professions that are doing compacts. They're becoming probably a little bit more popular or more acceptable, maybe, because you don't get licensed on a national level, but the more states that join a compact are getting close to that, to having a national license, the more states they get.
Maybe Gary or Ken remember that discussion, or Elaine, I don't know, but it seemed like it was a couple of years ago that we had that discussion, and it just wasn't vetted enough yet. I don't know whether it was ACA and MBCC that were kind of had two different versions of it, or what.
Well, my memory goes more back longer than that, related to allowing people to practice short-term in Kansas, and for being able to have oversight. So people had to make application to practice 30 days or something like that. And then, then when we did allow reciprocity, there was some discussion related to that too, to allow what was required to come in. But I don't remember anything that was this standardized, and the way, I think like architecture has a model program almost, so that, if you pass the national test, and you can almost practice in any state.
Yeah, it's all going to be based upon their Practice Act, and I've not been legal counsel to the technical profession, so, but that wouldn't surprise me that like architects have that where they can do national, so they can go across state lines for different buildings and certify them and so forth. So, but it's probably been more the exception than the rule for the other professions. But I think especially for the medical professions, I think that's where you're going to see these compacts become more popular.
Thanks.
It doesn't matter which board you go to, they all complain about the shortage. Teachers, nurses, doctors, physician assistants, police officers, they're all experiencing a shortage, either because people, don't want to go through and do the education requirements, even though some of them can be fairly low. Not all of them require a graduate degree in college, but if it's the pay or whatever it is that they're all experiencing shortages.
Any other questions? So I have a question for David. Has the NBCC approached anyone at the BSRB to get on the agenda for a meeting?
No one has talked to me. They sent the other document, the 3-page document in support of compacts, but there's no one who's requested to talk to the advisory committee or the board. But if you wanted to have someone come from MBCC, I'd be happy to contact them and see if they'd be happy to come and answer some questions and talk a little bit more about maybe why it's worded this certain way, or clarify anything. So
I think that's pertinent at this point. It sounds like, this is going to keep coming up. And so I'd like to go ahead and ask you to do that. Andrew Secor, I spoke with him. He couldn't be here. He sent an email saying he would like to be a part of that conversation. And so my question now to our committee, do we want to, well, we don't know when they could come, but are you in agreement that you would attend a meeting where the MBCC would be there to answer questions if we arrange it?
I would, yes.
Okay, so I see some head nods. So
my guess would be you're talking at the very earliest, the July meeting, because May is only 1 week away. So probably be July or September.
Okay.
Well, and actually, the advisory committee sometimes meets in the months opposite the board meetings.
Yeah, I was thinking board meeting. I'm sorry.
June.
Yeah. If you wanted to meet as an advisory committee, I could try to reach out to them for some time in June if that's what you wanted to do, but just wanted to leave it as an option for you. So.
Yes, please do. That would be great. And then I'll ask Andrew, I'll let Andrew know that June meeting, we assume that we'll be able to meet with them in June. And if any of you have any questions or, concerns that you have before then, Is it okay for them to, Jan, is it okay for advisory committee members to email me those questions so I can gather them and organize them for our meeting? Does that violate any capital procedure?
I think as long as either that or send them to David, maybe to gather them.
Okay.
Either way, the main thing is that you don't have any discussion about the questions, anything like that. If you just send them, so it's only informational, like it may be, because David has the server for his email is the state server, it would probably be best that they be sent to David so that they get on the state server. So they're preserved for the record retention.
Okay, great. So anybody with questions or concerns as you look through the documents that MBCC forwarded to us, just send them to David, correct? Okay. Anything else at this point about Compact? No? Okay. Okay, so let's move on to our next item. We need to discuss retention or disposal of practitioner records. We don't have a formal process for if somebody is incapacitated, if they pass away. And so one recommendation was to add a line on license renewal saying, I have a plan for my records should I be incapacitated or die. So we want to discuss that and see if that is something we agree should be in place. And so I would ask for any comments or questions about that.
I think we should have it. And I know APA has guidelines for practitioners. I don't know about ACA. I haven't followed that, but I definitely think that practitioners should make provisions.
Definitely. Anyone else? So do we need to officially ask that question or statement is added to the renewal, the license and renewal form?
Well, sorry, yeah, this topic came up, at the last board meeting, and they asked the advisory committees if the advisory committees could weigh in on this topic and then bring back some comments to the next board meeting. So I don't know that you need to have a formal vote on any position unless you want to. And sorry if that was not the question that you asked, but I just want to clarify that.
Yeah.
So I don't remember the details, but I do remember several years ago, the advisory committee dealt with record retention and how long they should be kept, and that was implemented. I just don't know if death was a part of that or not. Does anyone remember?
We, in our private practice, as they came in new, had them sign the ACA form that said if they left, were incapacitated, or died while they were in our office, who would be in charge of those records? And we did have someone that was licensed in Kansas in our office that passed away in, I think, 2008 or 2010. And I was in charge of those records. And then, of course, retiring, I have now left my records in charge of the individuals. And then we signed that. We didn't notarize it, so I don't know if that's legal, but at least someone was in charge of them.
I kind of think I know, like the Board of Healing Arts, they actually have it in a statute, what happens if you're deceased, about the process to go through, to retain records and so forth. And I think that's what the board was kind of entertaining as to whether they need to get statutory amendment or some kind of regulatory amendment to require not Because what you're talking about, when you're about professional associations, that's their guidance or requirements for their association. What we're talking about is for the board, which something that would become law that is enforceable, to make sure that they have plans on there so that they are incapacitated or if they become deceased, that the patients or clients now know how they can go get their records if they need them or to want to transfer them. So I think that's the question. Do you have anything in particular that you think this is a good idea? And if so, if you've got any kind of ideas on what should go into it, or if it should be a statute or something that the board would do through regulation.
I think people in an agency, it's not so much a problem, but it's people who are in private practice.
Right.
Is where I think the real issue is.
Agreed.
We were the ones that notified the BSRB that she had passed. When the family called about her practice, then I said, have you notified the BSRB that she's passed? And they said no. So you have an issue of notification. Of course, when the license comes time for renewal, you would have that. I mean, you would probably find more information about them not being alive, but we called right away and notified the state BSRB.
Correct, but BSRB doesn't have anything can't do anything about the records of them. And so I think this issue kind of arose last year when Max, before he retired, someone called and they were trying to get, I think it was the other way around. It was like a landlord wanting to get the records out of there, but he didn't know who to give the records to, because the family wouldn't go in and take over wouldn't clean out the deceased office and take the records and keep them and so forth. And so the landlord didn't want them, but he needed to get them out of there so that, he could go in and lease it again. And the way that happens under Kansas law right now is that if someone notifies the consumer division in the attorney general's office, then they go file the lawsuit to get the records and to take care of them. There's a process they go through to take care of. So that's what happened in that particular case, is they were notified then to contact the attorney general's office in the consumer division to go through that. But, if people don't call, that was just because they happened to call someone and Max got our office involved and we go, yeah, well, that's something our office can handle if they just let us know. That it's kind of a longer process, but this would be something, I think what they're wondering is to make sure that the licensees have a plan in place so that if something happens to those records, who has them and you can go directly to them without having to maybe go through the attorney general's office to go through that process and to get them and then to keep them until they can get the records returned to the correct persons. I think that's what they were trying to do, is to have it so that everyone knew that they had to have a plan in place as to what was going to happen to their records if they were no longer able to handle those records. So, and I think we looked at some provisions. I think we looked at that statute for the Board of Healing Arts, and then there are other states that do have provisions for this. And I think after that phone call, then we kind of started looking around, seeing that other states do have this kind of thing in place through statutes to make sure that it's client records can be handled efficiently and so that people know where they're at.
So I think we could all agree that there needs to be something in place. How to go about doing that is kind of what we're trying to figure out. Jan, you answered one of my questions. We don't want to encourage practitioners to not worry about it and then let the AG's office get the records and then having to go that long process. And you said, I thought, oh gosh, they're going to have to store all these records. But then you said you had to find out who the next person was that would be in charge of those records. So this is heading this off at the path and saying, okay, practitioners, you're responsible. You have to have something in place. So like for most companies or most businesses, you have an emergency staffing plan or something like that. And Elaine said, you know, that's their company. They did that themselves. But if, like Gary said, for private practice, people are not thinking that they need to do that. So we need to find a way to encourage them. And I even mentioned at another meeting to educate, you know, because some people may not understand that they needed to have that in place. So I think that it would be a good idea to put something in writing or get something out there, but I don't know who would really monitor that. And I don't know if that's something that the BSRB would, you know, be in charge of, because I don't know that that's possible. So that's the other part of it.
We all like to think that, you know, that's years down the road that we, you know, we'll do that later and then something happens and we're not immortal. I mean, kind of an example of this is that it's several years ago, it was a pharmacist, and I can't remember if he retired or died, but what happened is then the person who owned the building hired contractors to come in and remodel that the location of the pharmacy, and the contractor just came in and they had a big dumpster and they started taking all of the patient files that had all their prescriptions and all that and throwing it in a dumpster out on the street. And finally someone, you know, saw what they were, you know, realized what they were doing and made a complaint to the pharmacy board. And that's what you want to prevent, is that people just coming in and dumping clients' files with protected medical information from reaching the public. And that's kind of, it's public safety, you know, especially for the clients, to protect their information. So that's things like that, you know, are what makes the news. So that's what you don't want.
I like the idea of having a line on the license renewal form. And even if it was just as simple as, this is the person, this is the contact information for the person who has agreed to take my files, then if we are contacted, we can look and see who is the person that they left in charge, and we're able to contact them. It seems to me like it could be a little more formal, but at least that much information.
And it could hopefully be a clinician or someone in the field.
Right.
Well,
That'd be a requirement.
you know, the problem is that all of us are going to die. So, you know, I get someone's records, and then who do I give them to? Well, I believe that there is an agency connected with the limestone storage areas in Kansas City that collects records for professional entities, and they have a system that they file so that agencies can go get, I'm not sure of all the details of this, but I know that it is in existence. So, you know, personally, I would much rather have some kind of an entity. You know, if this rarely there's a need, but I think it really complicates it when you just give your record to some individual and, you know, historically to keep track of it.
I agree, but I think there's some expense involved, and a lot of private practitioners probably couldn't afford to do the storage like you're mentioning. That'd be the only thought that I would have. But they're only 7 years, so they would age out, and hopefully the person that would have to take over the files and the files would age out, and they wouldn't have to care for them, you know, that long.
Except with children, isn't it till they're 18, or is it 5 years after they're 18?
I don't know. So David and Leslie, are you aware of how any other states are doing it right now? Or should that be our next step to kind of find out, is there a standard model?
So I think we did look at a couple of states at the last board meeting. I want to say it was Texas, and I think there was one other state, and I don't recall the specifics about those states. And Jan, you may have forwarded those documents. Do you recall what those states were doing in terms of the records?
Texas had, I think, one for, if someone was incapacitated or deceased. And then there was another one we looked at, but they were more for the client wanting to get their files, not so much if the practitioner was incapacitated or deceased. So it was just I don't recall that we had like any practice acts that we were looking at. And I don't know if any of the practice acts even have those provisions, but that would be something, a starting point would be rather maybe before contacting all 50 states would be to contacting the different associations to see if they have anything in a model act, to look at, because those are a lot of times are good places to begin your thought process and the discussion as to what's in a model act or a practice act that someone else has.
Well, this issue, it seems to me, isn't unique to counselors.
Correct.
It seems to me it crosses various professions that the BSRB takes care of licenses, and so it seems to me there would be consistency across that, as opposed to, for example, us coming up with a resolution for this for counselors. Just a thought.
Yeah, I don't think they were wanting to limit it to just professional counselors. I think they were looking for all the professions under the BSRB umbrella. So probably it would sort of be like a lot of your other regulations or statutes where each act would have their own provision, but they would be probably identical.
Yeah, that was my point. I think there's no need for us to come up with a resolution for this when it seems to me, even though there's separate acts, that the BSR, the board would be the one, it would seem, or some other entity come up for resolution, because it seems to me they would be, if not identical, at least very similar.
Yeah, like the Board of Healing Arts, like I said, what their similarity is with BSRB is they have a lot of different acts that they, where they issue licenses, but they have one statute on this that applies to across the board to all licensees. And so to do that, where you'd have one statute across the board, you could put that, but theirs is different though. It's that, I haven't looked at that since a couple of months ago when that issue kind of came up, but it's like that there's established kind of a committee or something within the Board of Healing Arts that has the authority to charge fees to go in and get the records and to preserve the records and to keep them until, they can find, to get them to the owners if the owners come. So that if you do that kind of thing, then you could put it under the Enabling Act for the board, which is in Chapter 74, rather than in every practice act. But that's one way to handle it, but I don't know if that's the way the board wants to go, but would be to look at that model. But again, it's then kind of like still comes under within the BSRB purview, where it's a subgroup of that that would create a committee that goes and that gets the records and goes through them, retains them, and there's fees involved for doing all of that. So it's going to be a little bit more complicated than as if you just have a regulatory authority requiring all of the licensees to have a procedure that's going to be in effect as to who takes over, and that whatever it is that the clients and the person who's going to take over the records would know that, so that everyone knows who's going to be responsible and who they can go to. I mean, so there's different ways about it. It would be something like the Board of Healing Arts, or if you just want to say each licensee is responsible for having a process in place on what to do so that the clients will know.
So Ken, it sounds like you're suggesting that what the BSRB decides for all the governing disciplines is really what you want to be able to look back to and have counselors follow.
Well, you know, that's kind of a policy issue on how the board wants to go about it. But I think what they've always strived for in the past is it's something that should be uniform across all of your acts. Then, you know, that you put it in each and every act and the language is the same. Such as like 4 years ago, they went in and changed their discipline statutes across all of the acts. And so that they read almost, if they're not identical, they're very identical, because before they were so different. And so that's to get some uniformity in there, because it helps the board members, you know, understand all of the acts, because you know, like social worker isn't just there for the social worker act, and the psychologists aren't just there for the psychologist act. You have to administer all of those acts. And it was also sort of, I think, the policy that, you know, you're all behavioral sciences practice or profession. And so you all sort of have the same obligations and responsibilities. So I think that's why they were thinking, you know, what is the input from each of the advisory groups on what they feel is necessary and how to go about implementing it.
Got it. So that being said, are there any other suggestions from any committee members about what you'd like to see us take back to the board? Okay. And if you have anything, please notify David. It can't come through me. It needs to go straight to David Feig. And I'll also ask Andrew Secor to do the same thing since he's not here. Same thing with Ken.
Yeah. If you send anything to David, just send it to David. Don't make it a group email.
Okay. So that way, right. Okay. Okay. So our last item of new business, consideration of CE requirements for diversity, equity, and inclusion. So some other states, you know, obviously diversity, equity, inclusion is a very important topic. And there are other states adding requirements. And so we want to talk about, do we want to do that for counselors? Requirements of CEUs. So David, what can you add for that?
Yeah, so you're right. This has been something that has been sort of a big topic of discussion at the national level for some of the professions. And some of it has to do with, you know, looking at the number of continuing education hours that are required, but there, you know, you have a lot of different areas you could obtain those hours in. And so some states or national organizations are promoting, requiring that there be a certain number of hours of your continuing education hours you're already obtaining, but have maybe something like 3 that would be required to be in diversity, equity, and inclusion. The professional or the licensed psychology advisory committee had some advocates that came before the advisory committee and specifically requested that there be a change to have 3 hours in that area every renewal period. And so there was a discussion of that committee, and the Marriage and Family Therapy Advisory Committee also had a discussion about that topic as well. And they were clarifying too, that these wouldn't be 3 more hours that you would need to get just of the hours you're already getting, that 3 would need to be in that area. In terms of the mechanics to do this, it would require sort of a statutory change. And I think maybe there might be some regulatory changes as well, but it would require a bill change for the statutes to be modified in this area. So, so that is one thing, but the advisory committees are sort of starting to have the discussion on that topic. there might be interest in having something like this be an across the board type requirement for the professions, or it could be something where some professions just want to go ahead and take action on this. And so that was the discussion that's already happened in a few of the advisory committees. But I have also heard it, as you mentioned, at the national level as other states are considering proposals like this. So that is what I have heard.
So any
Well,
idea?
what about changing the 6 hours of diagnosis, 3 hours there, 3 hours in diversity, equity, and inclusion, and 3 hours of ethics?
That's one option.
Yeah, I could go along with that. One of the things that's difficult is, I mean, at some point you end up specifying every different content area, which limits the places that you can, and the kinds of things that you're going to be able to get your 30 hours with. So I'd be in favor of making that kind of an adjustment, sure. But
And one thing I wanted to clarify too, so one question came up at some of the, at least one of the other advisory committees about, let's say that something might qualify for more than one category, and how would the BSRB treat that? For example, what if you had something that qualified in both the ethics category and also might qualify in this category as well? Would taking those 3 hours satisfy both the requirements? And traditionally, what the board has done is it has looked at designating these 3 hours satisfy this, and then looking for 3 other hours or 6 other hours to satisfy other requirements. So currently right now, the historical practice has been to treat each hours separately and not have them count for both. So that would just be something too. I just wanted to throw that out there in terms of, you were talking about not wanting to have the hours, too many hours designated for different topics. So I wanted to make sure you were all aware that the current practice has been not to double count the hours if it counts for multiple categories.
I think diversity training and staying up to date is important. I even teach the class where I'm a professor at, but again, I'm not sure, do the other professions of the BSRB have a specific multicultural class that they must take in order for their degrees? I don't know whether they do or not. We do.
Leslie, do you know about that? If the other professions might require a class? And
I'd have to look. Some professions require you show us the coursework and some do not. So, social work, we don't look at the coursework, so I couldn't say, but I'd have to look.
I would say if they don't now, they probably will in the future, just by the way, things are kind of moving also. So that's something to consider in this as well. But we're also talking about not just individuals who are freshly from college graduated, we're talking about older professionals and requiring the additional, 3 hours or whatever it would be. So, and I think, isn't there another requirement for safety or something that was implemented like 7 years ago or so?
For social work.
It was social
workers, because they go into the houses of their clients.
Right. So that would be an additional one, at least for that profession as well. So.
Well, personally, I like your idea, Gary, of taking the 6 hours and making it 3 and 3. I think I think on the one hand, it's too bad that it's a reactive kind of a situation as opposed to saying it would have been important anyway, to have inclusion, diversity, and equity topics as a part of it. I think what it does is puts it up at a level of importance there are other topics I think that are important. This has become to the forefront now. And so I think I think now it seems to me it would be, at least for me, it would be pretty hard not to have that in my hours, because conferences that I've gone to now have made it a pretty important part of what goes on. Plus there have been specialty workshops. So anyway, I'm inclined to think to do it that way. It's not saying that, you know, you'd hope people would have done it anyway, but this puts the, you know, doesn't leave an option for some who might not have done that. So I think doing it 3, 3, and 3 makes sense to me. It certainly allows flexibility. And it's just looking at professional issues. So anyway, I like the 3, 3, and 3 to have it in there.
Well, the reason why diagnosis and treatment is, you know, when we first got licensure, there were a lot of people who had not been exposed to that as a part of their training program or are going to be licensed. So I think in this day and age, diagnosis and treatment is a pretty standard type course that's available for students to take. So I don't see the need for the CEUs the way it was back when it was originally required.
It feels like a natural shift based on how things have changed to go ahead and take 3 of those and use them for diversity, equity, and inclusiveness.
Well, and if this hadn't happened, it could have probably been reduced anyway, you know, that, so I guess that would make it more natural, but I think those are, the 3 are critically important topics. There likely are others, but those are at least 3 that should be required.
Any other feedback about that? So do we need to make a motion for that to shift the requirements?
So you could make a recommendation to bring back to the board. I know that the other advisory committees have been considering options. So I think you have some flexibility here. You could either take an official position and make a recommendation as advisory committee, or just take back the comments, but there's nothing to stop you from making a recommendation if you feel comfortable doing that at this point.
I'll make a motion to add the 3 CEUs for diversity, equity, and inclusion as a part of the 30 CEU hour requirement to replace 3 hours of diagnosis and treatment.
I second that.
All in favor, say aye.
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 All opposed, say nay. Okay, motion passes. Thank you for that. Okay, the last thing we have is old business, and although we call it old business, it's something that, you know, it's old in the sense that it's been going on for a while. At the American Association of State Counseling Boards conference, it was brought up in our breakout session, the challenge of closely related fields to counseling and how it somewhat dilutes the definition of what it means to be a counselor. And the thing that kept being brought up was art therapy. I don't know a lot about the history of all of this, but it seems like art therapists are kind of, you know, they've become an example. So I want to know if there are any things we can and should do to help support art therapists, but also delineate the work that they do from counseling, and even down to some of the complicated cases we have for licensure. You know, it's certainly coming up in an ongoing basis. So I don't know exactly what I'm asking the discussion to be, but I feel like we need a discussion about it. Anybody have history with this or strong opinions about it?
Well, I'll make, you know, What about music therapy?
Right. Yeah.
What about hypnotherapy? I mean, to me,
Therapy.
the medium should not define the theory. And to me, counseling traditionally comes from a broad-based developmental perspective, and the emphasis is not on the medium.
I was going to say that you, and Leslie, you were around when all this happened too. So correct me if I misstate anything, but the statute for professional counseling licensure said you had to have a degree in counseling.
Mhm.
Then they went through the statute several years ago, and it got amended to what is it, a degree in counseling or other related fields. Is that correct, Leslie?
Right, and 60 hours of graduate level.
Yeah, and they still have to meet the required hours and so forth. And this education still has to meet all the requirements for the educational institution. But when the board went with the legislature to make that amendment, what they were talking about, and that they, for some reason, someone had the idea that they didn't need to go in and define what it meant by or a related field. But at the time when they did that, what they were discussing, as I recall it, wasn't all these other, because there's a lot of degrees. There's been also applications for industrial psychology and stuff. But what they were and I think there's one even in business, some kind of that we've seen. But what they were discussing at the time was to have, if they had a degree in one of the other behavioral sciences, that they could maybe still qualify to get a degree, to get a license in professional counseling if there are other education for that, for a different type. So if they got a degree in marriage and family therapy, then that would be a related field that would allow them to go into professional counseling. But that has never been defined. They've never gone in and done a regulation to define that. So I think the question becomes, then, do you want to do a regulation that defines what a related field is? Is it one of the other behavioral sciences? Is it broader than that, or is it narrower than that? Because I thought a lot of people thought that like a psychologist would be someone who could probably do professional counseling. So I think that was kind of the impetus to that, was that someone who maybe went to a school and got a psychology degree, but there wasn't a professional counseling degree, but they could still come in and get licensed as a professional counselor. Is that kind of how that all came about? Leslie, is that your recollection, or do you have something else that you remember?
Yes, because we had several people who were licensed out of state, who had like a psychology degree, or it didn't really matter, but the program was a counseling program. It had all counseling coursework. They had to take the NCE and the NCMHCE. I mean, down the line, it met all the requirements except it said psychology. And that isn't the case in our state, but it is in other states. And that's when they decided to look and make a change. It wasn't to allow anyone with a different degree to get licensed. They still had to meet all the coursework and program requirements.
And you have, I think it's marriage and family therapist and addiction counselors that have that related field, and they've defined by regulation what it means to be a related field. But yes, for some reason, someone didn't think that was necessary and they dropped it. And so the Professional Counselors Advisory Group has never come forward with a regulation to put before the board as to what a related field means. And I think that's what they're asking you, is how do you want to define a related field for counseling so that it can be put in a regulation and we can put some meat on that bones to make it clearer for applicants that a degree in equine therapy or music therapy or art therapy or a degree in physical therapy, whatever, is not a related field. Or it doesn't even have to be therapy. It could be like the industrial psychologist. That's not a related field.
So is this question then coming from the board itself?
No, it's not coming from the board itself. It was something that I'm bringing up because I just see it as a loophole that needs to be defined or closed so that, there have been a number of cases in the last year that I've been aware of that were quite frankly over my head to understand because they were about aligned degrees that people were trying to get counseling, LPCs in the state of Kansas, and they were very complicated. And so it seemed to me like we need to be able to define this to make it easier on the BSRB, and so that those applicants really know what changes they need to make or additional training they need to make to, qualify for an LPC.
Let me raise an issue here just to kind of test the water. There are some master's programs in, let's say, Jungian psychology that are not broad-based counseling training programs. They have a very narrow focus. And so those individuals, even though it would be in the behavioral sciences, should they be licensed as professional counselors?
Right. There's an Adlerian school in Chicago that's in the same situation.
Mm-hmm. How
Well,
in California.
Even, and again, Leslie can probably, she knows all the details of this like the back of her hand, but even though it's a related field, the program still has to meet the requirements of the statute and regulation. So it doesn't just, it's just like a degree in counseling. That degree still has to meet the same has to meet the qualifications that's in your statute and regulation. So it wouldn't match. So if consequently, if your statute or regulation described that they have to have this broad concept and they don't have it, then they haven't met the program that they got their degree in doesn't meet those qualifications. That may or may not be the end of it, because a few years ago, the board went and got a statute, because that's what they were finding, is that someone who went and got, like, say, their degree out of state may be missing 1 or 2 classes for licensure. So a lot of people that were so close to getting over the finish line couldn't get there because they were missing 1 or 2 classes. So they have a statutory amendment that says if someone is deficient in the qualifications, then the board can allow them to go take the additional coursework that they need to get licensed. And so then once they complete that coursework, then they're good to go to get the full license. So, because what they're trying to do is to the legislature wants more people licensed. The board's trying realize there's a need for more licensees. And so that was a way to get hopefully more licensee here, that went to school someplace else, so that way they can meet get to those qualifications rather than just a complete outright denial, which would keep them from ever being licensed in Kansas, to just doing this, whatever it was, 2-3 hours that they needed to get licensed. I don't know if that helps answer your question or not. It's not going to work for everyone, but it was an attempt to get more people to license that were so close.
One of the people that applied that had a psychology degree was a nationally certified counselor, but she couldn't get licensed here. It was that kind of a situation. It wasn't, just to let everyone in.
Yeah, it's not meant to open up the door, but it's to try and get people who are so close to get them over the finish line so that they can get that licensure.
But does there appear to be a logical remedy for this situation after that conversation? And what?
I have language for the definition of a related field that the committee had talked about before. That I could bring to you at your next meeting.
Okay. And so are we saying that, we want to entertain related fields, of course, or related degrees of study, but that we are going to provide some clear language as to what might be necessary to avoid what?
Well, having it in a definition is, the big purpose of it is so that the public and the applicants know exactly, because, they may have to pay an application fee just to find out, I'm sorry, your degree doesn't get you there. But at least if it's defined in a regulation, then they come closer to knowing that, oh, this degree won't work at all, so I'm not going to waste my application fee.
So the language would be increased definition on a regulation level.
Right, like in a definition statute that you have for your professional counselors, you would go in there and define what a related field means.
Okay.
It'd be like for purposes of KSA, whatever that statute is for licensure for professional counselors. So for purposes of that statute, a related field means, and then you will have to come up with a definition for what a related field is.
Okay.
And of course, by the time you go through all the process of starting this conversation and discussion and presenting it to the board, and the board has that, and then you go through the process of getting it in a regulation, you're probably lucky if the regulation would be effective even a year from now, because you're just now on the cusp of it.
Right.
One of the problems is Illinois gives an LPC to art therapists. So in reciprocity, they'll apply to Kansas.
Yeah, but then under our reciprocity statute, the requirements for licensure in the state have to be substantially similar to what Kansas requirements are. And then if they weren't, then they don't qualify for reciprocity in Kansas.
They can't for 4 years of practice.
Yeah.
They can apply and meet reciprocity then.
Okay.
It's not just Illinois either. We're finding more people applying for it.
Well, and it would take statutory amendments, but you could license like all these different kinds of therapists, but perhaps, not so that they can only practice under the supervision of someone who holds a license in one of the other fields. So it'd be sort of like a subset.
From people that have called, that I've spoken to, a lot of it is reimbursement.
Mm-hmm.
They don't reimburse art therapists.
That was the testimony at that hearing is that she didn't care, but her employer did.
Mm.
So, that's the only other route I can think of. I don't know how much interest the board has in it, but if the therapists do, then that would be one thing, would be to go get licensure under statute where it's sort of a subset where they're practicing under the supervision of someone else who is licensed as a psychologist, a marriage family therapist, professional counselor, all those things. That's sort of like what happened with behavior analyst a few years ago, is that they could not get reimbursed from insurance companies because they weren't licensed. So they went to the legislature to get the licensure as a behavior analyst so that they could get paid. But in reality, they were going to change just the insurance. That's how it started out, was they were going to change the insurance statutes. But at the last minute, the National Association of Behavior Analysts came forward with a licensure act, and it got put in the way it is. So BSRB, there's so few of them that there's never been any amendments to make it so that it sounds more like our other licensure acts. It's quite a bit different. But I think that's just I think it would help for the board as well as the applicants to have an idea of what a related field is.
So that language, the definition in that language is really what would be most helpful in your opinion?
Yeah. And I don't know, I wasn't a part of the advisory committee. They didn't ask me anything to appear to address the language. So what they were considering years ago, I don't know what it was. But like I know when they were discussing the statutory amendment, that was what they were thinking of, was other people who are licensed on under one of the other acts that the board did, such as and I think the big one was psychologist. And I don't know if was there a marriage and family therapist who were also applying, or was it just psychologist? I can't remember. I know psychologist was a big one.
Psychologist, I think, was the biggest.
Well, originally when we got licensure in 97, there were lots of people in Kansas who had degrees in education, a master's degree in education. It did not say a degree in counseling, even though that was their training program. And it took institutions of higher education about 2 years to go through the Board of Regents to get their programs titled a master's degree in counseling. So originally that's where the related field came from.
Yeah, if you look in the Kansas State Department of Education regulations that on their website, and it says to be licensed as a school counselor, you have to have a degree in counseling. It doesn't say that you have to be licensed as a professional counselor by BSRB. It just says that you have to have a graduate degree as a graduate degree in counseling. So it's kind of odd is then, well, if they have to have a graduate degree in counseling, then they don't have to be licensed. That's not real clear from what Department of Education says, if they also still have to be licensed as a professional counselor. You would think so. but the regulations don't say that.
Well, the state education department, they came up with licensure a few years after LPCs were licensed. So historically, school counselors were not licensed. I don't know whether they were registered or what by the State Board of Ed, but so that evolved later for school counselors.
Well, neither were teachers licensed, they were certified.
Yes.
Which is typically what it was referred to, certification, and the boards were certification. And so when that licensure was changed, I mean, school counseling is not the only one. Teachers are all licensed now, or those that meet the criteria are licensed, called licensed teachers in Kansas, as is true of.
If you want to read one of the most confusing licensure regulations, look for teachers. They have teacher license, certificates, registrations, endorsements. It's a big maze. And Leslie must have looked at them because she's laughing.
I was thinking, I'm glad it's not ours.
Yeah, I'm glad they got their own legal department, but it's a whole different animal.
Well, part of that comes from historical evolution of that process, certification process, the whatever, the endorsement process. It evolved over many, many years.
They get a license and then they can have that added on to their license to show that they have a specialty. They can't call them a specialist unless they've got certain degrees and specialist and all that, endorsements, all that stuff. It's very complicated in my mind.
If you say it's complicated, I'm just going to believe you. Think you ought to know. So it sounds like what you're saying is we need to really make sure that we have good language around allied areas of study. And Leslie, you said that you had some of that language that you could bring to the next meeting?
Yes.
Okay, so can you provide it before the next meeting, include it in the agenda, so that way everyone can get a chance to look at it and then give feedback at our next meeting?
I can do that.
Thank you so much.
You're welcome.
Anybody have any other feedback or questions today about this topic? Okay, thank you for the discussion on this. I don't have anything else in old business. Does anybody else have any old business they want to bring up before we adjourn? Okay, it sounds like I need, oh,
Sorry, Laura, one thing. Did you want us to go ahead and tentatively plan on the next meeting being in June?
yes.
Okay.
Not on the calendar. Did we not go that far with our meetings? I'm sorry.
I'm sorry, what was that?
Do we not have a June meeting scheduled already?
Well, right
Yes and
now,
no.
so the first Monday is usually when the Professional Counseling Advisory Committee has been meeting.
Right.
So the first Monday in June would be on Monday, June 7th.
Okay.
So if you want, I can go ahead and put that down on the calendar and then get it registered, and then talk to Andrew, and we can reach out to MBCC and have a representative see if they can come to the next meeting on the 7th.
That would be great. And can we go ahead and put our August meeting on the calendar as well? So that way we can plan ahead since it's summer and travel is happening. Really.
Yeah, it looks like that August meeting would be first Monday of the month would be on August 2nd.
Great. Okay. Hopefully that works for everyone or most everyone.
Second. Is that what you said?
June 7th and August 2nd. Yeah. Okay. Anybody else? Other business? Okay, then I would look for a motion to adjourn.
I so move.
So Elaine makes,
Elaine, I so move.
need a second?
Yes, second. Is that 10 o'clock for both meetings?
I'm going to say yes. I assume that works. Okay, yes. I see David nodding yes. And Gary, was that a second to adjourn?
Yes.
Okay. Okay, all in favor say aye.
Aye.
Opposed?
Aye.
No nays? Okay. Thank you so much, everyone.
Thank you.
Take care. Thank you for everything.
Hey, everyone.